Welcome back to The Explainer. So today, we are tackling the legal armor that protects your real estate investments, property caveats in Singapore. Now, you probably already know that property transactions take time, but today we're really zeroing in on the mechanics of land registration. We're going to look at what a caveat actually is and how it acts as an absolutely non-negotiable legal shield during the most vulnerable stages of a sale.
Okay, let's dive into this. Here is our roadmap for today. We'll start with the property buyer's dilemma, check out Singapore's land registration system, understand property caveats, look at valid claims, and finally, what cannot be caveated.
Part 1. The property buyer's dilemma. Buying a property isn't exactly like buying a cup of coffee, where you just hand over cash and walk out with the item, right? It's a drawn-out legal process, and within that process lies a very specific, high-stakes dilemma.
Picture this for a second. You have found the absolute perfect property. You've signed the contract, and you've handed over a massive deposit check. But here is the catch. Your name isn't actually on the certificate of title yet. During this stressful limbo phase before formal completion, what happens if the owner tries to sell to someone else? How are you legally protected from just losing your deposit? Well, to understand the solution, we first have to look at the rules.
Moving on to Part 2, Singapore's land registration system. To grasp exactly how we protect our rights during that vulnerable limbo phase, we have to establish how land registration actually functions, who owns what, and how that is proven to the rest of the world.
Looking at the evolution of land registration really highlights why being officially registered is just an absolute necessity today. Under the old common law system, the Registration of Deeds Act, or RODA, registration wasn't actually compulsory. That meant establishing a quote-unquote clean title required a painstaking 15-year historical search. Contrast that with the modern Torrens system, which was adopted in 1960. The old deeds, gone. They're replaced by a single definitive certificate of title. And registration is no longer optional, it is mandatory to transfer an estate. Literally, if it's not on the register, it hasn't legally transferred.
Let's move to the mechanics and see how this builds. Under the Torrens system, documents have to be lodged in approved forms, either manually or via the STARS e-lodgement system, to be reflected on the land register. But wait, remember our buyer's dilemma from earlier? Because their sale isn't legally complete, they hold what is called an unregistrable interest. They can't just go put their name on the title yet. So, how do they survive this gap?
Which brings us to Part 3, Understanding Property Caveats. To bridge the gap between signing a contract and achieving full legal registration, the system provides a specific mechanism for these transitional interests. Enter the hero of our narrative. Now, what's really interesting here is that a caveat is essentially a giant, legally binding do not disturb sign. It is a formal legal notification entered right into the land register, used to protect an unregistrable interest. By lodging a caveat, you are officially calling dibs on the public register, and this actively prevents the registration of any other dealing that would defeat your claim.
But here's an absolutely critical fact you have to remember. A caveat is not a permanent claim of ownership, no way. It is a temporary legal shield that lasts for exactly 5 years. This effectively pauses the clock, preventing new land titles from being registered and giving the caveator the breathing room and time they need to invoke the assistance of the court if a dispute actually arises.
And this brilliantly illustrates just how much legal weight this carries. It provides a form of temporary protection with an effect very similar to an injunction. In legal terms, an injunction is a super powerful court order compelling someone to stop a specific action. By acting as a statutory injunction, the caveat literally freezes the status quo, totally stopping the registrar from approving any transfer detrimental to the caveator. Part 4. Valid claims for caveats. Okay, so we know caveats are incredibly powerful tools that can freeze property transactions. But who exactly gets to wield this power? Because the land register is so strictly controlled, you have to have a recognized interest in the land itself. We're talking legal interests, like a lease exceeding 7 years, and registrable interests, which brings us right back to our purchaser who is waiting for legal completion. It also covers beneficial interests under trusts, agreements of charges like CPF refunds to protect your retirement funds, and even liens for unpaid taxes. All of these represent a very direct, transitional tie to the physical property.
Which leads us to Part 5, what cannot be caveated. Because a caveat acts as an injunction freezing a property's title, the system cannot allow it to be abused. So, the crucial point is that there are strict boundaries. You can't just throw a caveat onto any property. While pending purchases and CPF refunds are perfectly valid, there are hard lines drawn for invalid claims. For instance, licensed moneylenders, they are explicitly banned from lodging caveats on HDB flats. Plus, general creditors are strictly prohibited from doing this unless they have a direct order of court. You literally cannot just caveat someone's house over a personal loan or some unrelated business debt. Similarly, a mere licensee, someone who only has permission to use the premises, cannot lodge a caveat either.
The reason these rules are so strict comes down to one fundamental principle. Caveats are encumbrances, and the golden rule of real estate is that properties must be sold free from encumbrances. That is the ultimate power of the caveat. Just by existing on the register, it fundamentally freezes a sale because an owner physically cannot pass a clean title to a new buyer until that caveat is withdrawn, lapses after its 5 years, or is removed by a court order. So we've seen how the Torrens system relies on the title, and how caveats act as this essential 5-year protective shield for buyers stuck in that vulnerable, unregisterable gap. It really is an elegant solution to a very stressful dilemma. But it does leave us with a pretty provocative question. Since caveats and charges sit quietly on the land register, acting as these invisible legal injunctions, what invisible encumbrances might currently be lurking on your property's title? Could there be an old CPF charge or a forgotten caveat? Knowing how this system works is absolutely the key to protecting your real estate reality. Thank you so much for joining me on this explainer, and as always, keep questioning the fine print.